For generations, coal communities across our nation have made the sacrifices, done the heavy lifting, turned our country into a global energy leader. Many of these communities still bear the scars of those sacrifices in the form of abandoned mine lands as a result of decades of unregulated surface mining that occurred prior to the passage of the Surface Mining Control and Reclamation Act of 1977, known as SMRE. Whether it's acid mine drainage impacting rivers and streams, subsidence, and landslides threatening homes, businesses, and infrastructure, or dangerous mine openings, AML sites pose serious risks to the health and safety of communities across the country, particularly in Appalachia. 5.5 million people in Appalachia live within 1 mile of an abandoned mine land site, including 1 in 3 West Virginians. That is why Congress has taken several steps to address these issues and ensure no one in these communities are left behind. Congress passed SMRE to perform 2 important functions. First, for mines that were already abandoned in 1977, SMRE created a funding mechanism for states to reclaim those lands left in coal communities across the United States. The AML program is funded by a fee levied on coal companies to assist states with reclamation and cleanup efforts on mine sites that were abandoned prior to the passage of the law. This program has proven to be vital to the safety of these communities. Second, for operating mines going forward after 1977, SMRE ensured mine sites would be adequately reclaimed by the owner during and after operations. SMRE also established the Office of Surface Mining, Reclamation, and Enforcement, or OSMRE, whatever that's. OSMRE? OSMRE? Yeah, thank you so much. Within the Department of Interior to administer programs created by the law to ensure the environment and communities across the country are protected from legacy and active coal mining hazards. I'm disappointed that this office does not have a Senate-confirmed director. Cannot believe it. And I'm frustrated that the Biden administration has yet to even nominate a candidate. When the AML Reclamation Fee Collection Authority was expiring in 2021, I was proud to work with my friend Ranking Member Barrasso on a bipartisan compromise to extend the fee for an additional 13 years. This agreement was ultimately included in the bipartisan infrastructure law to provide certainty to communities with millions and even billions of dollars worth of unreclaimed mine sites. The AML fee is extremely important, but unfortunately that alone will not be enough to address all the unfunded AML issues across the country. That's why that we included an additional $11.3 billion for AML cleanup in the bipartisan infrastructure law. West Virginia is on track to receive roughly $140 million per year for the next 15 years to address AML problem areas through the funding. To put into perspective how much of the game changer this is for my little state of West Virginia, we only received around $15 million from the traditional AML program for fiscal year 23. Our state's bipartisan infrastructure law allocation for this year is more than 8 times that amount. The bipartisan infrastructure law is finally providing the funding our state needs to make our communities safer in counties all across West Virginia. I'm thrilled that Bob Rice from the West Virginia Department of Environmental Protection, who leads the state AML program, is here with us today. I look forward to hearing his perspective on the implementation of this important funding. The AML provisions in the bipartisan infrastructure law are not just about protecting the safety of these communities, they are also an investment in our future. If implemented effectively, the bipartisan infrastructure law's AML provision could result in approximately $4.3 billion in economic output for the state of West Virginia, 1,910 jobs that will continue for 13 to 15 years, according to a report from Downstream Strategies. As one example, Western University has done extensive research into extracting rare earth elements from acid mine drainage, providing an opportunity to strengthen our domestic supply chain for critical minerals while cleaning up streams, creeks, and rivers that are impacted by legacy pollution as part of the AML program. It is truly a win-win. And speaking of win-wins, nothing could be a better example of how to make communities safer while finding productive uses of this once unhospitable land than through the Abandoned Mine Land Economic Revitalization Program, or AMLR. AMLR provides grants to West Virginia, Pennsylvania, Kentucky, Ohio, and Alabama, 6 Appalachian states with the highest amount of unfunded priority AML problem areas, in order to explore and implement strategies that return AML sites to productive use through economic community development. One thing I want to say very quickly, Appalachia with our unbelievable terrain is why we have so much of this. My dear friend, they harvest coal in Wyoming. We have to mine it. The AMLR grants to West Virginia, oh boy, that threw me off.
So many ways in which Wyoming is superior, yes.
As a member of the Appropriations Committee, I'm proud to support the AMLR program each year through appropriations process. From salmon and lavender farms to a new Hatfield-McCoy trail system, West Virginians are finding innovative ways to revitalize coal communities that have been impacted by abandoned mine lands that are wisely leveraging these federal funds to help make it happen. While I'm thrilled by the ingenuity of many West Virginians who are trying to make their communities better places to live, I've been disappointed to hear some of the concerns about how the AMLR program is being implemented. And these concerns are not unique just to my state. States get to choose which projects they want to see funded, but they are beholden to vetting of OSMRE in order to receive project funding. I fully support robust vetting to ensure that we are being responsible with taxpayer dollars, but I'm alarmed to hear how delayed the process has been. AMLR projects in Kentucky, for example, experience an average total vetting process of about 700 days, almost 2 years. These coal communities sacrifice everything to power our nation to greatness and should be able to implement projects that will have positive impacts on the community in a timely manner. They sure as hell don't deserve to be strung along by the federal government, tied up in bureaucratic red tape, and forced to wait to put transformative projects into action. It's absolutely unacceptable. A long approval process for AMLR is unfortunately not only the problem, the administration is seeking to force new and sometimes retroactive rules on AMLR projects, such as requiring projects to record a covenant that gives the federal government extensive control over the land being used for these projects. These rule changes ultimately slow down assistance to our coal communities and send the signal that the federal government is working against them. This pattern throughout all of OSMRE programs is alarming. Unfortunately, suggestions by states to make AML programs run smoother often seem to fall on deaf ears, but not today. Let me give you an example. States like West Virginia must submit 3 separate applications just to receive their AML funding from the bipartisan infrastructure law, the traditional SMACRA AML program, and AMLR. These applications are not a small task and are filled with a lot of duplicative information that spans all 3 programs. State agencies have asked OSMRE to create a uniform process with less duplicative and burdensome paperwork, and yet no action has been taken to make the process more user-friendly. I'm grateful that we have Deputy Director Owens here today to discuss the hardships some of these implementations rules are putting on our state agencies. While a lot of programs mentioned today address pre-SMACRA coal mine land reclamation, I would be remiss if I also did not share my concerns about post-SMACRA mine land reclamation and the risk that could be posed by insufficiently bonded mines. Coal communities across the country are still trying to undo the damage of decades of unregulated mining earlier in our history, and we cannot risk adding further harm by piling on additional unfunded reclamation needs not covered by bonding. These risks are particularly acute in Appalachia, where the prevalence of underground mines instead of surface mines can make reclamation more challenging and even more costly. Deputy Director Owens and Deputy Cabinet Secretary Rice, I look forward to hearing your perspective on this issue today as well. While many of my colleagues in the committee do not have AML programs in their states because they do not have the same history of coal mining, many of their states do bear the scars of hard rock mines that were left behind without any reclamation. Since there is no equivalent SMACRA that addresses abandoned hard rock mines, it seems obvious that SMACRA will be looked to as a model as Congress considers changes to the mining law of 1872. As I've said repeatedly, it makes no sense at all to cart off federal minerals without any kind of royalty, especially as we leave communities suffering on ongoing consequences of legacy abandoned mines while taxpayers are on the hook for all the cleanup. So I hope the hearing will illustrate the lessons we have learned from coal mine land reclamation in this country and show how we can apply those hard rock mining reforms too. With that, I'm going to turn it over to my friend, Ranking Member Senator Brasso for his remarks.
Thanks so much, Mr. Chairman. Thank you for holding today's very important hearing. You know, the Abandoned Mine Land Program plays a vital role in supporting the reclamation of former coal mine sites in my home state of Wyoming and then, of course, across the country. The program targets the most environmentally hazardous coal mine sites in our nation, and communities depend on this program working efficiently to address threats to public safety. Coal producers in Wyoming are among the largest set of contributors to the Abandoned Mine Reclamation Fund. In fiscal year 2022, Wyoming contributed $54.9 million to the fund. This is nearly 60% of all the money received last year. So Wyoming's oversized contributions have existed for decades. This wasn't a one-time thing. And since the beginning of the program, only half of the funds that collected on coal production in Wyoming have actually made their way back to reclamation activities in my home state. Most of the fees collected on coal production in Wyoming go to other states with reclamation needs. In other words, Wyoming's coal production is essential to reclamation activities all across America. Despite this fact, the Biden administration has worked tirelessly to kill coal production in Wyoming. The Biden administration has blocked new coal leases. It has consistently moved the goalposts for lease modification requests. It has slow-walked permits. This strategy will only make it more difficult to reclaim the sites that we all agree need to be cleaned up. So instead of killing coal production, Chairman Manchin and I have worked to put the abandoned mine land program on a sustainable path. In 2021, Congress modernized the program by reducing the fees on coal producers and authorizing the reduced fee for 13 years. We provided relief to coal producers so that they can continue mining coal and funding the program. Because again, without coal production, there is no resource secure enough for funding for this program. So thanks, Mr. Chairman, for working with me on this important legislation last Congress. In recent years, Congress has made additional changes to the abandoned mine land program. We provide additional resources to address unfunded reclamation needs that total more than $9 billion. And we provided flexibility to states to determine how best to spend reclamation dollars. We recognize that states' reclamation needs are not identical and that one-size-fits-all approach will not work. Since Congress took action, the Biden administration has imposed new hurdles on states implementing the abandoned mine land program. This is despite the fact that states have over 40 years of experience carrying out the program. Ensuring taxpayer dollars are spent properly is a principal responsibility of Congress and federal agencies. This oversight, however, should not get in the way of achieving the objectives of the program. The new requirements that the Department of Interior is placing on states is going to take their attention away from the important work of mine reclamation. For example, the Department is now requiring states to assess the economic impacts of a reclamation project. It's also requiring states to assess potential greenhouse gas emission reductions of a reclamation project. While these may be interesting data points, they have nothing to do with the mission of the program. The mission of the program is to reclaim abandoned mines. Instead, the Department is going to force states to hire out experts and consultants and spend more time on unnecessary paperwork. This is a complete waste of time and taxpayer dollars. The abandoned mine land program is critical to the public safety and environmental quality of communities all across America. The Biden administration shouldn't twist it into another bureaucratic boondoggle in the name of climate change or so-called environmental justice. The Department needs to get out of the way and let states get busy reclaiming abandoned sites. Thank you, Mr. Chairman.
Thank you, Senator. And I'd like to turn to our panel of witnesses. We have today with us Ms. Glenda Owens, Deputy Director of the Office of Surface Mining Reclamation Enforcement at the U.S. Department of Interior. We have Mr. Rob Rice, Deputy Cabinet Secretary of the West Virginia Department of Environmental Protection, Director of the Division of Land Restoration, and a proud West Virginia. Rob has worked for the West Virginia DEP since 2006, where he's held various positions: abandoned mine lands, regional planner, AML regional administrator, AML chief. He has a bachelor's degree in wildlife and fisheries management, as well as a master's degree in safety and environmental management, both from West Virginia University. Rob also serves as a member of the Glenville State University's Natural Resource Management Advisory Committee. He lives in Charleston, West Virginia, with his wife and 2 sons. And it's always nice to have a fellow West Virginian here at the Energy and Natural Resources Committee. And thank you, Rob, for coming. Now I'm going to turn to Senator Barrasso to introduce his friend and our friend for coming.
Well, thanks so much, Mr. Chairman, because sitting next to that proud West Virginian is an incredible man from Wyoming, Don Newton, and he is here today, and he has traveled. Thanks, Don, for coming all the way from Cheyenne, Wyoming. He has worked to protect Wyoming's communities from environmental hazards for nearly 20 years. He has a bachelor's degree in geology from the University of Louisiana, and he also studied environmental pollution control at Penn State University. He has served the Wyoming Department of Environmental Quality since 2004. He was back when I was in the state Senate. And he is recently elected as the treasurer and the secretary for the National Association of Abandoned Mine Land Program. So congratulations, Don, on that election. Thanks for sharing your experience and insights with the committee today, and all of us look forward to your testimony.
Now we'll start with your opening remarks, and Ms. Owens, you'll begin.
Thank you, and good morning, Chairman Manchin and Ranking Member Barrasso. Thank you for the invitation to testify on behalf of the Office of Surface Mining, Reclamation, and Enforcement. Through the Surface Mining Control and Reclamation Act of 1977, Congress established OSMRE for two primary purposes. First, to ensure that the nation's coal mines operate in a manner that protects citizens and the environment during mining, and to restore the land affected to a condition capable of supporting the uses it could before any mining occurred, or to higher or better uses. Second, to implement the Abandoned Mine Land Program to address the hazards and environmental degradation resulting from 2 centuries of coal mining activities before SMCRA was passed. OSMRE's Title V program provides resources to 23 primacy states to administer their regulatory programs on state and private lands. These programs protect the public and the environment from the adverse effects of current mining and support the reclamation of impacted lands after active mining operations have concluded. OSMRE provides oversight of state regulatory programs and directly implements SMCRA on Indian lands and in states that do not have primacy. The Title IV program provides grants to states and tribes to conduct reclamation on sites before the where mining occurred before the enactment of SMCRA. OSMRE evaluates state and tribal AML programs and ensures that reclamation of mining-related hazards while promoting partnerships to address water quality issues. OSMRE also administers the Federal Reclamation Program, which includes watershed cooperative agreements, civil penalty projects, and emergency projects. Since the establishment of the Abandoned Mine Land Economic Revitalization Program, Congress has authorized through annual appropriations $912.5 million in total AMLR funding, with the purpose of reclaiming abandoned mine lands in conjunction with economic and community development opportunities. The AMLR program has provided funding to the 6 eligible Appalachian states, as well as the Crow, the Hopi tribe, and the Navajo Nation. OSM verifies and assists with project eligibility determinations on the submitted AMLR grant applications, and since FY 2016 has received over 290 project applications. Of those project applications, 284 have received preliminary approval, and nearly 180 have received authorizations to proceed, with almost 70 being completed. The bipartisan infrastructure law provided a once-in-a-generation investment in revitalizing the economy and environment of America's coal-field communities. In addition to extending the AML fee collection authority under SMCRA, the infrastructure law authorized and appropriated $2.93 billion for deposit into the Abandoned Mine Reclamation Fund, with approximately $10.8 billion to be distributed to eligible states and tribes on an equal annual basis, which is approximately $725 million a year over a 15-year period to help restore impacted coalfield communities. So far, OSMRE has provided $721 million in FY 2022 bill grant funding to the 22 eligible states and the Navajo Nation, and awarded more than $21 million in FY 2023 grants to 5 states, with 8 additional state grant applications currently pending. OSMRE is ensuring that current coal mining is conducted in a manner that protects the public and the environment, and that formerly mined lands are reclaimed to productive, safe, and beneficial uses. OSMRE will continue to work closely in partnership with the state partners to achieve these goals. Thank you again for the opportunity to provide this testimony and to appear before you today.
Thank you. Now, Mr. Rice, we'll have yours.
Thank you. Good morning, Chairman Manchin, Ranking Member Barrasso, and members of the committee. My name is Rob Rice, and I am the Deputy Cabinet Secretary of the West Virginia Department of Environmental Protection. Thank you for the invitation to speak with you today, as I am honored to provide West Virginia's perspective on issues surrounding implementation of the Federal Surface Mining Control and Reclamation Act of 1977 and the Infrastructure Investment and Jobs Act. I'm happy to report that West Virginia has awarded $53 million in design and project oversight contracts for the reclamation of 127 abandoned mine land sites with an estimated reclamation cost of $217 million. All of this possible because of IIJA funding. West Virginia has also granted $180 million of abandoned mine land economic revitalization, or AMLR funding, to 56 projects. While states have been working with OSM for over 40 years, we've experienced a continual layering of bureaucratic processes that occur without meaningful state input and often result in added work that lacks a proportionate amount of benefit. Since the passage of AMLR and IIJA, states have been excluded from meaningful discussions regarding their implementation. Significant decisions are frequently published as responses to FAQs on the OSM website without prior notification to AML program administrators. Additionally, states are unable to proceed with selected AMLR projects until OSM approves them through a time-consuming vetting process. Between 2016 and 19, OSM's vetting period for AMLR projects averaged approximately 3 months. This process increased to 5 months for the 2020 projects, with one project requiring 21 months. The projects from 21 encountered a 10-month vetting period, with 3 projects still navigating that process. Only one of the 22 projects has completed the vetting process, while the remaining 5 have lingered in evaluation for over 6 months. Active AMLR projects are also experiencing delays and additional obstacles. Recently, OSM introduced a requirement for deed-recorded covenants on AMLR projects and retroactively applied this condition to projects funded since 2016. The new policy prevents projects from advancing to construction until deed-recorded covenants have been provided. Contrary to OSM's belief that this only applies to a few AMLR projects, it will in fact be required on 38 of the 56 of those in West Virginia. Many of these projects are already in progress, are currently under construction, or have been completed. The lien covenant option is not directly applicable to protecting the federal interest. The terms and conditions of the subgrants awarded to our agency already necessitate compliance with all federal and state laws, rules, and regulations, including 2 CFR 200. Commonly referred to as the administrative rule. Section 200.316 states that real property, equipment, and intangible property that are acquired or improved with a federal award must be held in trust by the non-federal entity as trustee for the beneficiaries of the project. It further states that the federal awarding agency may require the non-federal entity to record liens or other appropriate notices of record. A concluding thought on AMLR would be to allow those funds to be spent on post-SMCRA mine sites where reclamation has been fully completed and the permit has been through final bond release with no remaining SMCRA obligation. With passage of IIJA, AML reclamation is no longer in question. Expanding the use of AMLR funds to these sites would provide the most potential for beneficial redevelopment and would better support our coal communities. Moreover, as states grapple with efficiently and effectively deploying the increased AML resources provided by Congress through IIJA, OSM is diverting AML program managers' attention to a meticulous review of historical legal authority. This endeavor seems unnecessary given that these programs have operated for over 40 years under continuous OSM oversight. Each AML project must go through the authorization to proceed process, ensuring that they comply with federal law before funding is released. OSM's inability to approve 55 pending plan revisions and program amendments across the country highlight the impracticality of the comprehensive program review it is currently conducting. West Virginia alone has 10 amendments pending approval. These date back to as far as 2009 when this committee's chair was our governor. Lastly, SMCRA coal regulators Lastly, SMACRA coal regulatory programs have a very urgent need for an increase in federal funding. Over the past 2 fiscal years, Congress has appropriated $65 million each year for regulatory grants to states for operation of these programs. This is a reduction from $68.59 million Congress provided for these grants on an annual basis over several previous years. We thank the committee for the hearing today. OSM and the states have a similar goal of carrying out the mission of SMACRA. Our hope is that this hearing will aid in bringing OSM and the states to a point of mutual agreement on many of the issues we will discuss today. Thank you for the opportunity to testify, and I look forward to answering your questions.
Thank you. Mr. Newton.
Good morning, Chairman Manchin, Ranking Member Barrasso, and members of the committee. My name is Don Newton, and I am the Administrator of the Wyoming Abandoned Mine Land Division. Thank you for providing the state of Wyoming with the opportunity to share our perspective of the AML program. DEQ's mission is to protect, conserve, and enhance the quality of Wyoming's environment for the benefit of current and future generations. The AML division addresses these principles through reclamation of abandoned mines and assistance to mining communities to eliminate public health and safety hazards and address the challenges presented by historic mining. The AML program in Wyoming provides real benefits to the state. This includes the mitigation of hazards while creating jobs and associated economic benefits for communities near AML sites that face their own economic challenges. Since its inception, Wyoming AML has reclaimed over 25,000 acres and has closed more than 2,500 mine openings. Between 500 and 800 people are employed in Wyoming through AML reclamation projects annually. The reauthorization of the AML funding passed by Congress in 2021 reduced the AML fee on produced coal by 20%. However, the Bipartisan Infrastructure Law, or bill, added new funding to address legacy abandoned coal mines. For Wyoming, the additional funding offset the reduction in the AML fee so the total funding is about the same amount we had received in recent years. Wyoming appreciates the additional funding, which keeps our program whole, allowing for the continued mitigation of hazards. The reauthorization of the AML fee, combined with the infusion of the new funding under bill, shows clearly understanding by Congress of the need and the value of the AML program. There are some areas where changes should be considered that could improve the AML program and benefit Wyoming and other states in better utilization of the funds provided by Congress. OSMRE is requiring all states to update their reclamation plans. Wyoming recently submitted an update to our plan in 2020, which was approved in 2021. We see no reason that plans should be required to be updated simply because of the addition of the bill funding. All AML states are currently working under an approved state plan, and requiring unnecessary updates adds no benefit to the reclamation of historic mine sites. The existing plans are adequate and robust enough to address both the fee-based and build programs. Requiring states to update their plan consumes essential resources and budget that would be better applied to reclamation. The successful implementation of the AML program is largely dependent upon a strong relationship and trust between OSMRE and the states. When the trust breaks down, effective implementation of the program and the benefits to the public suffer. An example of where the trust has eroded is related to the project lists that OSMRE required to be submitted with each build grant application. Wyoming joined with other states to work with OSMRE to develop guidance language that would satisfy that perceived need by using problem area descriptions in a manner that was effective for the states. Language was agreed to by both OSMRE and the states, but when OSMRE's 2023 bill grant guidance was released, it did not include the agreed-upon language. This erodes trust and does not comply with the principles of cooperative federalism. The National technical training program managed by OSMRE is the key to providing training for new state staff. OSMRE should hire professional instructors instead of relying on state AML staff as instructors, which adds an unnecessary burden on already stressed programs. Additionally, there have been many recent retirees with vast experience that is an untapped source of trainers that OSMRE could contract with. Finally, it's been requested for many years that the training classes have an Eastern and Western regional focus, as the reclamation challenges are significantly different due to topography and rainfall. Program efficiency is important in Wyoming, as evidenced by our ability to run our entire program with a staff of 12. Demands on staff resources for things such as revising our reclamation plan unnecessarily detract from the real work of the AML program, addressing public safety concerns by mitigating hazards and reclaiming abandoned mines. Thank you for the opportunity to testify.
Thank you, all of you, for your testimony. We appreciate it very much. And now we're going to start our questions, and Senator Barrasso will begin.
Well, thanks so much, Mr. Chairman. Let me start with Ms. Owens, if I could. You know, a Wyoming coal mine, Black Butte, has been pursuing a lease modification for about a decade. At multiple points in the process, your office has suggested the review was just about complete, only to change course and then require an additional review. Last month, the office did it again. The office informed the company that it must now complete an environmental impact statement before it will agree to the mine plan modification, before your office will agree. Why do we keep moving the goalposts for this project?
Thank you for that question, Senator Barrasso. I'm familiar with the situation in Black Butte. What happened in that situation, you're correct. We had been working on an reviewing under an environmental analysis for the mine, but a recent 10th Circuit Court of Appeals decision was rendered that had direct impact on several of the issues that we were reviewing and the analyses that we were performing for the environmental review for Black Butte. And that required, we did a legal review, we had a legal review done, and it was determined that the decision required an environmental impact statement rather than an environmental assessment. And one of the reasons that we want to make sure that the decisions that we make during these environmental reviews will sustain judicial scrutiny, because for us to get in litigation, most, if not all, of our NEPA decisions are in fact litigated. And if we don't adhere to the controlling court decisions, we're going to risk getting those decisions vacated or having to start all over, which is just going to require additional time.
It just seems to me that the excuse of litigation, which is real, the litigation is real. It often justifies inaction of permitting decisions, withdrawing, changing, moving the goal lines. I just don't think it should take a decade to obtain a lease modification, and at some point there's a responsibility to act on the mine plan modification, and if sued, defend it in court. It just seems that 10 years is too long. Mr. Newton, the abandoned mine land program depends on cooperative federalism, as you've talked about. That means that the states execute the program with guidance and support from the appropriate federal agencies. How could the Office of Surface Mining improve its relationship with states to ensure that the program runs smoothly?
You hit on several points about additional tracking and things like that that pretty much across the board all the states say is unnecessary and is going to create a bunch of burden for us and not improve any mine sites. We have communicated that with OSM. And another thing that we see that could help out is, if they want us to put the work on the ground, get the mines closed, then not having separate grant applications, multiple grant applications when they're the same We had suggested, when we had heard that the bill funding was coming down the pike, we asked them if you can put one grant application for both bill and fee-based, you would save a tremendous amount of time for the states, and we could not waste so much resources. So those are just a couple of points that we have tried to communicate with OSM. It doesn't seem like that they hear what we say, but they don't really realize what a burden it is for the states.
So following up, in my opening statement, I explained that the Office of Surface Mining seems to be throwing up what you said, new hurdles for states to access funding to reclaim abandoned mine lands. The hurdles include a requirement that states assess the economic impact of reclamation projects. They also include a requirement that states assess the potential greenhouse gas emissions reductions of the projects. What impact do these new requirements have on our ability in Wyoming to carry out the abandoned mine land program?
I think, Mr. Chairman, I think that trying to evaluate how much greenhouse gas emissions is coming off of a 2-mile-long high wall, I don't know that anybody can do that. I mean, you could guess at it, but I don't really see the value in it because you're not, I mean, you're generating data, as you mentioned earlier. You're not really closing off the mine, and you're wasting huge resources.
The abandoned mine land program supports high-priority mine reclamation work across the country. Can you talk about some of the projects in Wyoming?
You're familiar with the small town of Hannah, which is a coal community. That's the only reason it grew there. It's a town of 700. The coal mine is closed now. We just finished our first bill-funded project. It was, the tiny town has 2 arterial paved roads that go to it. One of those roads has been closed for 2 years because the subsidence from the mines below it had surfaced and created holes right in the middle of the road. So the county had to shut the road down. We finished that project, very successful. We know it's a gigantic benefit for the community, safety issues for fire trucks and things like that, but we don't know how to put an economic impact on that value. That's not what we do. We close mine sites.
And they just opened a really beautiful Boys and Girls Club program in Hannah. I was there for the ribbon cutting and the grand opening. So thanks, Mr. Chairman.
Thank you. And I'll start my questions now. And first of all, I just heard from Rocky Atkins. He's a special advisor to the to the governor in Kentucky, Governor Beshear. He's very much concerned because in eastern Kentucky, they're getting hit as hard as we are, and they've got so many problems over there. And so I know that, Mr. Rice, you can speak on their behalf too, because you all work very close together with them. And if you will, Rob, explain to me basically, you know, I looked at the program. We put this, first it was called the AML pilot program. That went on for 7 years. We're way past the pilot program, or should be, and now I understand we have more challenges today than we had when we started. Can you give me a little bit of direction on this and what you think we can do? And Mr. Newton, you'll jump in here too. We've got to fix it, and we want to help Ms. Owens, and we got to make sure that we're able to direct the energies we have and the resources to fix it, because people are desperate to get this done, and they'll never have another opportunity like we have today to do that. Sir?
Thank you, Mr. Chairman. I appreciate that. As you stated, the AML or the AMLR program started as a pilot to give you an idea of what we experienced initially versus today. So each year we receive new guidance prior to receiving the AMLR funds, and each year that guidance document becomes thicker. So there's more hoops to jump through. The vetting period has increased over subsequent years. So, you know, from our perspective, we have projects that the state feels comfortable moving forward with, Kentucky feels comfortable moving forward with, because that's why they advance them up to OSM to go through the vetting process. But as the program has evolved from the pilot up to what it is today, it has the same intent, and we're able to get to the same point, but the process that it takes to get there is much more difficult. So and it could be as simple as a grant application process. You know, are the requirements that have to be included in the application, you know, seem like they increased. The guidance, as I stated, that has increased. And then, you know, there were two issues that came up that have really made us scratch our heads as to whether or not this is a loan or an economic development program. And that has been program income and then deed recorded covenants. So when we talk about program income, if a project is funded and they implement their project and then it becomes successful and there are revenues made from the advancement of that project, we were told that those monies can't be, nothing can happen with those monies unless it's reinvested back into the project. So we have examples of individuals who have received funds, constructed projects, and now we're telling them that for a period of time, you can't actually make any money off of the project. You have to then instead reinvest those funds back into the project. So that's the program income side. And then I think that came up 2 or 3 years ago.
That's a block right there.
It
Who would
is.
do it? Ms. Owens, can you speak to that? Is that what you intended?
Thank you, Senator. Thank you. The issue of program income, as well as some of the other issues that have evolved over the implementation of the program, you know, we have, when those issues have arisen, we've sought legal advice and been given legal advice and are following the advice that we've received in terms of how that program income needs to be treated, as well as other issues that have arisen. And Mr. Rice's characterization that they can't use that money, one of the requirements for us in administering this program is to make sure that the funds that we have, the federal funds that we've awarded, are being used for the purpose for which they've been granted, and that is to support those AMLR projects. And so that the advice we've gotten on program
Where do you get
income
your advice from? Where does your advice come from?
from our solicitor's office.
Uh-huh. Okay, maybe we better get them in front of us. Ms. Newton, you have some input on this? The main thing is there's so much bureaucracy. We know, especially in hilly country where we come from, we don't have much flat land. Reclaimed mine land is what we are using our construction sites. If it's done and done right and put back. At first, it used to require they to put back the contour and this and that. Made no sense at all because we needed building sites. We needed construction sites. And we were trying to change that. And now to have this where you can't use the money and you can't make money off, what the heck are we doing with it? Are you running into the same thing out in beautiful Wyoming?
No, we are not running into the same problems that the Appalachian, the AMLR states are. We're generally able to put our money on the ground. We certainly have a lot of projects to handle, but I will tell you that being on the executive committee for the National Association of Abandoned Mineland Programs, I hear all the issues that all the states are going through. And my counterpart in Kentucky sent me an email and said that they have $101 million of projects waiting for approval
Oh, it's
for
unbelievable.
AMLR.
Yeah, that's what Rocky called me about that. He says, you just won't believe our backlog.
Yeah.
Let me say this, Ms. Owens and Rob and to Don here. What you're running into, or you're saying that basically the way the law is constructed now, the code will not allow you to give him the permission to do what needs to be done to get more people involved. Is that correct?
Not exactly. That's not exactly.
Rob,
what
is that the way you understand it?
The way I understand it is we are rewarding, you can make a characterization here.
We're just,
but
we're
we get the
not
impression-
condemning anything. We're just trying to find a solution to fix some of these problems. So speak freely.
We're rewarding the projects that fail and punishing the projects that succeed. And that's,
I would really like to understand that better.
I know,
Because
that's
that's
what-
not our goal.
I know it's not your goal, so we're going to figure this out. We're going to get everybody together in our team. If you need to have code change here, we have good people here. Senator Daines, all of us come from these types of situations, and we want to make it work and make it fluid. We're here to help. We're not here to condemn.
Yeah, and I just want to say that, you know, OSMRE is not sitting here making these decisions without working with the states. We attend and work with the National Association of Abandoned Mineland Programs. We work with the Interstate Mining Compact Commission. We have a collaborative partnership with the states. We don't agree on all the issues, but we are looking at it from a different perspective. We're looking at it from the federal perspective, but do not want to, it's not our goal or intent
Okay.
to throw
Well, how do we-
burdens and obstacles.
Maybe we have a lack of communication here to basically, to talk about what really needs to be fixed. When I just pressed Rob a little bit, he says, I can tell you what, we're rewarding those who fail, and we're basically punishing those who succeed.
And that's what I really would like to have more
Can
discussions
we do
on and
that?
to
Okay.
understand.
Don, you have, your greatest challenge you have with OSMRE.
We certainly meet with them frequently. We have, as Glenda had mentioned, 2 IMCC meetings a year. We have 2 in-person association meetings a year. And we frequently, we've had work groups ever since the beginning of Bill. We've had work groups that many states are on and OSM, to work through these issues. And some of the issues we've worked through, we think. But it does seem that when every one of the states is adamant about an issue like updating their reclamation plan, it just falls on deaf ears.
Can I
And-
say something about the
Sure.
reclamation plans? So one of the things we looked at when we began to develop the guidance on bill implementation was the extent to which and if reclamation plans would have to be updated. Now, our regulations do require the reclamation plans be updated, but what we did was reach out to the states and said, we will engage in informal reviews with you just to look at your plan and only focus on those that might be necessary to be updated that are provisions related to the bill. We didn't do the whole thing because that would be, as has been indicated, it would draw resources away from getting the work done. But we have a schedule, we are meeting with, having informal reviews, pointing out to the states where the bill provisions might
Let me
require.
tell you how bills, we might have the best intention in the world here on this committee to do a bill that really helps everybody. By the time it's implemented, interpreted and implemented, it's completely different than what we intended. And sometimes you think it's been codified, we don't, and you have to challenge it. Okay, we do that too, in rural review. What I'm asking to do now, Mr. Rice, you're here today, right? Have you have a meeting with OSMRE while you're here? Is it possible that you can meet with them today?
Absolutely.
Can you all get to, Don, you want to too? After this meeting, and you all can sit down, we'll find you a room here, or if you want to go back to your office. This is how we had to get things fixed, because we're not accomplishing. I can tell you this, what I need to know from you, Ms. Owens, is this. What do you believe that law is codified that you have to do? And what do you believe that basically through your regulations and rules and regulations, it's been interpreted that we can change and back you up in changing these kind of interpretations that aren't really codified, or they're kind of not really clear? We just need some, now we'll back you up in some common sense that helps get the job done. That's where we're running into, I think, a roadblock. I know I've taken over, but we have Mr. Daines here, and Steve comes from a beautiful state of Montana, and he has a little bit of hilly country too. Steve?
We do, Chairman Manchin. We got a lot of coal as well.
Yes, you do.
Thank you, Chairman Manchin. Thanks for that thoughtful discussion just now. Deputy Director Owens, the Office of Surface Mining is required by a court order to complete environmental reviews for 3 major Montana coal mines. For all 3 mines, OSM sets deadlines for the completion of the environmental reviews, and in each case, OSM has now pushed those completion dates further and further and further down the road. If you all were punters, your legs would be tired right now. And for all 3 mines, if OSM does not complete their environmental reviews in a timely fashion, the mines are going to run out of permitted coal. Let me say that again. If OSM does not complete the environmental reviews in a timely fashion, these mines are going to run out of permitted coal. Behind me is a frightening chart. It shows the dates that each of these coal mines, when they run out of permitted coal, and the current date that OSM has told us they will finish their environmental reviews. For every one of these mines, OSM now says they will finish after the mine runs out of coal. OSM must take this seriously and focus on finishing each review in a timely manner. Deputy Director Owens, I want to start with the Bull Mountains coal mine near Roundup, Montana. In December of 2022, Judge Malloy required OSM to complete a new EIS, even though OSM had already completed 3 environmental assessments. Now, originally, OSM said they would complete the EIS in July of 24. Now, you're saying June of 25. It's my understanding that the mine will run out of all permitted coal by September of 24 and will be forced to close unless OSM finishes the required permit. That means jobs, livelihoods. Look, places where these mines exist are not the same places where the show Yellowstone takes place. These folks oftentimes have to have several jobs to make ends meet, but these are the best paying jobs in these areas. These are places here where folks are struggling right now in many, many ways to make ends meet. But their livelihoods are going to be lost because OSM is dragging its feet. So here's my question, Deputy Director. Will you commit to me and the people of Montana that OSM will finish your required environmental review before September of 2024? Because that's when the mine runs out of coal.
Thank you, Senator Daines. What I can and will commit to is that OSMRE will work as expeditiously as possible to meet that deadline, which we have been doing. As we are conducting these environmental reviews, as I mentioned, court decisions come out that change our focus oftentimes and require us to engage in, to pivot and undertake additional reviews and analyses. And that's what we've had to do in all of these cases. In each of these cases, Spring Creek, Rosebud, and Bull Mountains. And we change and do those reviews and analyses that are required by these court decisions, because again,
that's not a commitment. What I got you says you're going to try your best. That's different than saying we're going to get this done, because you recognize we're going to close the mine down if we don't get this done.
A little bit more than try our best. Work as expeditiously as we can with the others in the department that we are working with to ensure that we get it right so that we don't have to go back and do it again.
So you know, when we first heard from OSM, they said, okay, it's going to be July of 24, which that worked because the mine runs out in September of 24. And then we come back and say, wait a minute, now it's going to be June of 25. This isn't all going to work, but this is just argument number one. We're going to get to 2 more mines here, because I tell you, I think what's happening here is there's folks who want to slow roll this because they know if time's on their side, they can slow roll this and shut all 3 of these mines down. But look,
Senator,
this is not coincidence. I want to move to the Rosebud mine near Colstrip and the Spring Creek mine in Bighorn County. Similar situations. OSM has pushed these deadlines past the point required by the court order. This puts at risk the same jobs, the communities supported by these mines. And further, because the Rosebud mine feeds the Colstrip power plant, it threatens the energy security of our state. This is the baseload power that keeps the lights on. Will you commit to completing the environmental reviews before, you see the same chart here, before the May 2024 deadline for Spring Creek and the April 2024 deadline for Rosebud?
Senator, I can assure you that we are doing all we can to meet those deadlines. We're doing all we can. One of the things that's occurred is we've had to look at additional, by court order, we've been told that we had to look at additional low-carbon alternatives, which put another layer onto the review that we were doing. And so we cannot ignore that. We have to address it. And we are putting resources on it and moving as expeditiously as we can.
So if you can't commit, which you haven't, would you commit to petitioning the court to extend the deadlines so these mines don't have to shut down?
Well, actually, we have had discussions with,
I'm
believe
asking the
it's
question, will you petition the court to extend the deadlines so these mines don't have to shut down?
to extend the deadline for the environmental reviews.
You gave us, we've got to, the court needs to push, because the deadlines has come from the court. OSM
Yes.
says we can't get reviews done now in time to meet that. We need you to petition the court saying you got to push the deadline out.
Well, we can certainly ask for an extension on the deadline from the court. We would want to do that in collaboration with the mine operator.
So the answer is, I just want to make sure we're clear. These aren't trick questions, or I'm not trying to play. I'm
Right,
just
and-
saying, will you commit to petitioning the court? Because this is where we've got the disconnect here, is the court set a date, and when you all came back to us the first time and said, we'll have these reviews done, it was within that timeline, and folks said, it's going to be tight, but we can make it. Then OSM punts it. On all three of these mines, and now we can't meet it, and all three mines were shut down, so we need help petitioning the court. And my question, will you petition the court to extend the deadlines?
What I will commit to do is to go back and meet with the solicitor's office, because they're the ones who know the requirements for seeking an extension from the court, and I will work with them and determine whether that is something that we could do at this time. And it's certainly something that, if it's possible, we would.
Does it concern you these three mines are going to shut down?
It does.
Why does it concern you?
It concerns me because, as you said, the folks in those communities are dependent on the resources and the funding that comes from this.
Yeah.
It's the benefits to the communities, and that's what the Surface Mining Act is all about.
Not to
Benefiting.
mention, not to mention reliable, affordable, resilient power, too.
Absolutely.
On top of all that.
Absolutely.
So I'll wrap up here. But I just, as I look at what's happening here, just count me as suspicious that it's a coincidence that in all three of these mines, the date for the completion of the environmental reviews is after the date where every one of these three mines runs out of coal.
That is an unfortunate coincidence, but I can assure you it is not intentional, and I will, as I have committed,
Yep.
speak to the solicitors and see if there's something we can do to seek an extension.
When to petition the court, and then I want to get a detailed understanding from OSM as to why these dates are getting pushed back, and why is it to the policy of OSM to miss these court-ordered deadlines and ignore the on-the-ground reality is occurring in each one of these instances. Three. I mean, if it was one, I'd say, okay, we're going to have a debate about one. You guys went 3 for 3 here.
And several of the issues involved in all three of those reviews, Senator, are similar, and are ones that recent court decisions required us to go back and take a look and make sure that we would, in our analysis, be able to sustain judicial scrutiny. We don't want to have to go back again after we spend the next 6 or 7 months getting this done, having it litigated, and it will be litigated, and having a court tell us, go back to square one. We
And
don't
just-
want to
I'm
do
done.
that.
But here's the problem, too, is that when you shut these mines down, then folks have to go find other employment. So it's not like you just shut her down for a little while, and then we start it back up again. We lose these mines.
I understand.
All right, thank you.
I think what he's asking for is your support, basically, of accelerating so they don't shut, because when a mine shuts down, the pumps go off, they fill up with water. It takes almost, it's impossible sometimes to bring them back. And you lose that, you lose everything. So that's what he's asking for. But that meeting today, maybe, there's a meeting, Steve, that Ms. Owens has been gracious enough to say that she's going to have with Mr. Rice and Mr. Newton. If you want to have somebody at that meeting.
Yeah, no, and we would. We'd love to have somebody there, and thank you. I mean, this is it's a significant issue for us back home in so many ways, and we want to make sure you hear from us what we're seeing, and we want to work with you, petitioning the court, because we got to get these court dates pushed out so you all can meet those deadlines and we can keep the lines running.
Ms. Owens, what we'll do also is I'll have Ms. Zahaba Urecki, my person in my Energy Committee. She'll be there in the meeting with you all. So we just want to get some answers and see how we can help accelerate this. Senator Hickenlooper, you're up.
Thank you, Mr. Chair.
Okay.
And I appreciate it. almost never watch television in the morning, but was watching CNBC, and the chair was on talking about the fiscal commission with great eloquence. Let me start with Ms. Owens. With over 1,700 abandoned coal mines, top to bottom, east to west, across Colorado, we appreciated the almost $10 million it was in the abandoned mines lands funding from the bipartisan infrastructure law. Appreciate that more than we can say.
Yes.
Again, it was a key area that was announced when she was in the state last week. I want to ask, just it's not enough, but is it your intention or hope that we can get future funding from that as we go through and work on these abandoned mines and we're going to put it towards fires in abandoned mines?
Yes, Senator. As a matter of fact, one of the recent legislative pieces, the STREAM Act, does allow the states to put 30% of their bill grants into a long-term reclamation fund where they can treat mine fires and subsidence and other hazards that had
Collateral issues, right?
Yes, other collateral issues.
Yep, no, I got that. And the fires are a big part. Mr. Rice, we are going to try and put out some of these long-standing fires in coal mines that we've got 38, I think, actively burning, some of which have been burning for decades and would burn for decades more, spewing out all kinds of noxious emissions that aren't doing anybody any good. I think without treatment, well, I've been told some of them could burn for centuries. Anyway, they present a massive wildfire risk. We had the Glenwood Springs coal seam fire 20 years ago, burned 29 homes, almost 12,000 acres. Mr. Rice, what problems, what challenges do you think we face in putting out underground fires in West Virginia, for example, and how is that funding, how do you utilize that funding most efficiently to fight this challenge?
Thank you, Senator. Great question. So putting out underground mine fires is actually probably one of the more difficult feats that we try to tackle when it comes to abandoned mine lands. And so you have two different types of underground mine fires, those that are below drainage and those that are above drainage. The ones that are below drainage are pretty rare, and that's because, you have groundwater that helps make sure that those don't, become something that would, permeate and be long-standing. But they still do exist. So Centralia, Pennsylvania, if you're familiar with that, that's a situation where you have a below drainage underground mine fire that has persisted for maybe over 100 years. In West Virginia, we also have, both types of situations. But to answer your question, how do we address those? It really depends on the impact that particular mine fire has to the community. So the amount of investment in extinguishing the fire is going to be weighed against how much benefit will the community receive. So, for example, we had an underground mine fire in Fairmont, West Virginia, Whitehall, where we did an initial phase of the project, which was just make sure that the community was safe. And we did that by removing the outcrop or the barrier coal associated with that underground mine fire. We then came back in and did grouting associated with that project and did further excavation. But the only way to put mine fires out with 100% certainty is to remove all the overburden and then actually, shovel by shovelful, move that coal out and separate it from the burning material and extinguish it. So it's a very labor-intensive and difficult endeavor.
I appreciate that, and that's the way it is. Mr. Newton, acid mine drainage, another serious environmental safety hazard, requires active water treatment to fix, repair, remediate. Again, these become very expensive problems to solve. States can use part of the money they receive under the Abandoned Mine Lands Program on acid mine drainage in coal mines, but there are no similar programs existing for hard rock mines. In Colorado, we've got some coal mines, but we've also got 23,000 hard rock mines, which cause significant water quality impacts from acid mine drainage. Can you discuss just a little bit the hazards and costs associated with acid mine drainage from hard rock mines as opposed to coal mines?
Mr. Chairman, Senator Hickenlooper, thank you for that question. You know, it's interesting that you asked me that question because Wyoming has no acid mine drainage. Now, we do have some mine drainage from hard rock, though, copper mine that essentially kills the stream where the trout can't live because copper impedes the absorption of oxygen. But, you know, the difficulty with treating water that's coming out of a mine, so, you know, the mine has created a conduit for groundwater to come out. It's leaching whatever the materials are that you don't want in the water out. And, you know, if you look at like Pennsylvania that does a lot of acid mine drainage treatment, you have a treatment cost of maintenance forever. So, you know, the STREAM Act was super helpful for all the states that have mine fires. We have mine fires, acid mine drainage, or subsidence issues, which are the three categories of work that we do that we can fund that way. So to be able to set that money aside is very critical. The treatment of water when it comes out of a mine is very, very difficult, very, very costly too. The copper mine I described to you is at over 10,000 feet. So you couldn't put a treatment system that's going to work there because you can't get there for half the year. So, you know, we really appreciate that Congress changed the bill to allow us to set that money aside. We do have a lot of mine fires, about 25 in Wyoming that we're tracking. Subsidence is our biggest issue. So those issues are going to be dealt with as long as there's an AML program in the country.
Right. Well, I'm out of time. Appreciate all three of you taking the time out. It's funny, you know, I have a master's in geology, earth and environmental science, and what we're discussing today, they don't teach you when you're getting your master's in geology until I was governor of Colorado. This is the first time I really became aware of this stuff. I think part of our job is to make sure more Americans are aware of these consequences of, you know, decades of whether it's fires or acid drainage that has been harming our environment. And I know you guys all know that, and I appreciate your work. Thank you. Yield back to the chair.
Thank you. Thank you, sir. I've just got a couple more. Do you have any, if you have a few more you want to ask, we've got a little bit of time here. You're more than, why don't you? Go ahead, Senator.
This is why he's considered the best chair in the entire United States Senate, as he looks after our time.
I'm the best energy chair they have because I'm the only energy chair right now.
Senator Barrasso might view himself as a vice chair. I don't know.
He's the best vice chair, and he would be the chair if he could, and I would be the vice chair.
And let me ask Mr. Rice and Mr. Newton, but although I think Ms. Owens, you could pipe in on this as well. Even with the massive infusion, $11 billion in the bipartisan infrastructure law, you're still having to prioritize on a feverish level where to go first and how to allocate your staff, your physical resources to, you know, the competing needs for these abandoned mines. With those priorities, especially around workforce, how would you describe the workforce challenges you guys are having to deal with on a day-to-day basis in your own states when you're talking about mine remediation, aside from the fact that most people don't know what you're talking about?
Yeah, great question. So I think there's two parts to it, and I'll answer the first part first. So how are we selecting the projects, and how are we, you know, deciding what we move forward with? So there's really two buckets that the first influx of money has funded. We have several projects that have just been too expensive historically for us to be able to fund. IIJA has allowed us to move forward with those projects. We also have an open, open dialogue with the public. And so on average, we receive over, 100 complaints a year of citizens that have concerns regarding AML features in the community. So we had mapping individuals put together or aggregate where those complaints were located. And so that's the second, area that we focused in, was to aggregate all of those complaints. And a lot of times what you'll find is mine drainage doesn't just impact one house, it might impact an entire community. Subsidence doesn't impact one house, it's an entire community. So those are the two ways that we have, taken this first step in spending the money. The large projects we couldn't fund, and those areas that have clusters of citizens that have, made us aware of problems.
Makes sense.
Now, what are we doing from a workforce standpoint? It takes the government time to staff up. And so I think the intent was to get the dollars on the ground as quickly as possible. So the state only hired or increased our staff by, I think, 6 individuals. But instead, we've hired consultants to act as, extensions of the state. So we have a planning division and a realty division and an inspection division and everything that you need to be able to facilitate a project. Instead of us hiring additional state employees to be able to facilitate the expenditure of these dollars, we're hiring consultants to do a lot of the things that we would do. And that allows us to be able to get those dollars on the street much faster.
I like it. Mr. Newton?
Mr. Chairman, Senators Hickenlooper, as far as staffing up goes, Wyoming has an entire staff of 12. We have 8 project managers, and we conduct business and have conducted business much like Rob has. We use consulting firms that design the projects, oversee the projects, and then we oversee them and the projects while it's going on. We have hired no new staff. We actually get about the same amount of money in Wyoming as Colorado gets, about $9.5 million annually. We could say we wish we got more, but that would mean we had more problems for historic coal, like our eastern counterparts. Your other question was, well, no, the workforce, we haven't staffed up at all.
Right.
I mean, it's interesting because if you look at Pennsylvania has 71 new positions in their AML program, and their AML program is 260 people, which is the size of Wyoming's entire DEQ. But they do everything in-house. They have a different business model, so they do almost all their design in-house. Although I think now with the amount of money they're getting, they're going to start hiring consultants as well. So, a lot of our work fuels the economy of Wyoming.
Right. Yeah, got it. Great. Thank you again, all three of you. I yield back to the chair.
Thank you so much. Let me just as we finish up here, I want to go through a few things. Ms. Owens, basically right now, you're telling me we know it's about 700 days for AMLR to get an AMLR process going through authorization. Can you explain why the vetting process is taking so long? Is it a shortage of people, resources? What is it?
Senator, there are a lot of factors that contribute to the length of time. The vetting process is where we work with the states and we try to provide them as much information up front before whether the proposed projects that they are receiving are going to meet eligibility requirements, meet the federal requirements. And as this program has evolved and developed, what we found is the number and scope and complexity of the projects and some of the issues and concerns that are presented are increasing. And so we want to work with them earlier. We want to identify where they are so that those issues
I'm saying it's gotten worse. So
it's gotten worse.
So why did it get worse? Did we put more? Did we, with our good intentions, make it worse for you, which happens a lot?
No, actually, I think what happened, and you alluded to it earlier when you said this started out as a pilot. It started out as a pilot,
Sure.
and it was pretty straightforward, but as it has evolved, there are additional the scope has increased, because this is a great program. You know, it's achieving reclamation in those impacted communities, it's developing and providing economic opportunities. And so we're getting more, the proponents are getting more creative. They're proposing projects that hadn't been proposed in the past. And so it requires us to do more detailed review and to work with the states earlier on. And this is not, you know, it's not just a linear process. This is an iterative process. When we get projects from the states that raise issues or concerns about whether they will in fact be able to be funded, we share that information with them, and the states will go back to the project proponents and they'll get additional information. They'll advise them on things that they may need to do so that they can get funding.
Let me just tell you how important, because I was just asking Zahaba here. We put $11 billion towards AML. $11 billion. There's a 10-year window. It ain't gonna get done. They don't get out the door. As bad as we need it, it'll just lay dormant, and it'll all be reverted back to Treasury. That's the problem that we're dealing with. We don't want that to happen. And only thing, Mr. Rice, I want to ask you real quickly, and then give you exactly what I think the meeting today should entail when you all meet, okay? But first of all, SMRE is basically the sins of the past. We had to pay for that, and we put a fee from every ton forward to pay for the sins of the past. Also, we put bonding in place. I was always concerned about bonding because I know what will happen. And right now, the coal business is better than it's ever been. West Virginia has never had a run like this before. Kentucky's never had a run like this before. Nobody in the coal business today has ever made this much money. It's unbelievable. Prices right now, I just saw the price this morning it's for just, it's around $90 just for thermal coal. Still about $170, $180 for coking coal. So there's no complaint there. Are we keeping up with the amount of bonding? The requirement of bonding is taking care, and do you have the personnel to evaluate, to put that property back the way it needs to be put back as you're mining? Do they have enough bonding to do it in case they just go kaput and leave and walk away or forfeit their bonds? A lot of them will do that, declare bankruptcies and forfeit.
Right.
Get stuck with that. We can't go back and repeat the same mistakes we made prior to SMRE. So tell me, if Rob, you think you're in place right now and you think you have a handle on that. And God help you out west with the hard rock mining. Since 1872, we haven't been able to do a thing. And I can give you many reasons why that's happened. It shouldn't have happened. And we're going to have to get real. The people out west deserve to have those properties reclaimed. And the companies need to pay a royalty, like everyone else, for the treasures of this great country. A certain amount, and a certain amount set aside. So we have a program in place that we think could be adjusted towards what needs to be done with hard rock mining. But Rob, if you can tell me on that, what you think, you're in good enough shape.
Great question, and it's, so West Virginia, as you know, has a substantial abandoned mine land inventory. So we're well aware of what the impact of keeping track of current mining, would have on the state should bonding not be sufficient. So the state has a special reclamation advisory council, and that group gets together and they look at the rate of forfeitures, the bonding, the tax on coal, and every 2 years an actuary is prepared that assesses the state of.
Let me ask you this, to all of you, whoever's involved in this, in all the Appalachian states. Can you tell me, since SMRE, how much we have been left with unfunded bonding or unfunded property? The bonds were inadequate, or bankruptcies that stuck the state with this mess?
So
I'm not saying right today, but I'm just saying, can you get that figure? Because I'm sure we have the same problem to a certain, I hope it's very small, and hope we can eliminate that.
Absolutely. So if a mine does forfeit their bond, that safety net is in place. And the state's comfortable with where we're at right now.
That's all.
So the actuary that is in draft, it's completed every 2 years. The projection is actually great. So it looks out 20 years. And so in 2043, the state's projected to be solvent with an estimated $180 million available to fund any reclamation that needs to happen. So as part of that, For example, in 2017, there was a thought that, we may need to increase the amount of money that can take care of these. So there was an increase on the per ton tax that helped fund the special reclamation program. So there's really two safety nets. You have the bond for the mine,
Right.
but then you also have the 27 cents per ton that goes on top
I
of
think
that
the
bond.
bonding is something you really have to stay on top to, and people that understand the bonding business should be advising you all to say, these people are underfunded. This bond is not adequate. Things of that sort, I'm hoping you know. So if you're just dipping into the state, because putting more pressure on that end of it, when it's a responsibility, and the coal business being as strong as it is right now, makes no sense why we can't carry it. Let me say this, we're going to wrap up the meeting, but what I want to tell you, I appreciate, Ms. Owens, the meeting you're going to have. I think it's imperative to have the people that are making decisions in that meeting, and Mr. Rice and Mr. Newton, for you all to be in that meeting. We're going to have Zahava will be there from my office. We have Rocky Atkins from the governor's office of Kentucky, who's sending us the concerns. What I want you to come away from that meeting is finding out where Ms. Owens' hands might be tied because something, the way the law or the way she's interpreting the law, or something that we can clarify here. If we can't, we'll put legislation in place that clarifies it so we can expedite these funds to get them out the door. That's what has to be done. And that's what we're asking, and I appreciate all of you accommodating today. So as soon as I adjourn here, we'll have Zahaba get with you all. I've got to go vote. They just called the vote. So I just appreciate very much making the effort. I know you came a long ways. I appreciate all of you coming from Wyoming, and Rob coming up from West Virginia, and Ms. Owens, you accommodating him today. It's very kind of you, and I appreciate that. We're all in this together.
We are.
We've got to make it work, and we want to make it work, okay? With that, we have until the close of business today for, Monday. Oh, that's right. Monday to submit their questions. We have a lot of senators in all different directions this morning. But anyway, they'll have till Monday to submit their questions for the record. And with that, meeting's adjourned.
Thank you.